This is Stan Garnett, District Attorney for Boulder County and potential Attorney General of Colorado. He's running as a candidate for the November 2nd election. Hopefully got that all right.
That's right.
All right, so real quick, I'll just introduce myself. I'm Jason Lauve, and obviously we know you, Stan Garnett, right. The DA of Boulder. And the way I sort of introduced myself to you, or you introduced yourself to me initially, was prosecuting my case, which was a possession charge of 34 ounces and also concentrates.
That's correct.
And that case ended up going to a jury trial where I was acquitted last August 6, 2009. And one of the questions I have for you in regards to that case is the jury foreman came out afterwards and did an interview with the Daily Camera and a couple of people that were also part of the gallery in the trial. And basically the jury foreman stated that it didn't matter what the amounts were. He actually said that I could have had a ton of marijuana, it wouldn't have mattered. They still would have acquitted me. What is your take on that quote? What is your
well, Jason, your case was very much it was kind of a seminal point in my first year as district attorney. When I first took over the office, I took over an office where people weren't doing a lot of trials. Everything was kind of handled by plea bargain, and one of the things I pushed was let's take cases to trial, which there's a lot of reasons for. They don't have much to do with what we're talking about today, but it makes better lawyers, better cops, if people have to air out what happened in a case in front of the community, because the trial is completely public. And the other thing that a trial does is it teaches me and my staff what the community thinks about particular cases. Trying your case helped everybody on my staff, and particularly me, have a sense of how the Boulder community views medical marijuana. And also, I learned a lot about the complexities of the medical marijuana scheme in Colorado and how difficult it was to do any prosecution given the way that Judge Birkenkotter instructed the jury in that case, which I think probably was correct. Mm-hmm. And what the jury foreman was talking about was essentially the instruction you got from the judge in that case, which said there are limits to the amount you can have under Amendment 20 unless the patient or his or her doctor believes reasonably that they need to have more.
Right.
Well, what that educated, I mean, you can't do criminal prosecution where you don't know what the rules are before they start. And so what I learned from that was, if that's the way medical marijuana law is going to be applied in Colorado, which I can certainly live with, then it's very, very unlikely that we would try another case unless we had some extraneous circumstances, because that's a subjective determination, and no jury is going to want to sit in judgment on a patient saying you have too much marijuana. Mm-hmm. Right. That was my take.
Okay, thank you.
And you know, just so it's clear for your viewers, the foreperson of the jury was reasonably hard on my office and on me for trying the case. We did what I thought was appropriate at the time, but we also did what I thought was appropriate afterwards, which was really kind of look closely at these cases. And I've tried to be pretty vocal about what I've learned about medical marijuana.
Yeah, you're coming from a totally different standpoint at this point, is that correct?
Yeah,
it sounds like you've learned quite a bit.
I think pretty different standpoint, yeah.
What are the three most important things that you've learned in the last year in regards to the efficacy of medical cannabis in terms of the medical use?
Sure, well let me quickly answer another question that'll set up that answer. Okay. What I've learned as DA is that to be an effective district attorney, or really to be effective in law enforcement at all, it's all about priorities. You only have limited resources. What are you going to focus your resources on? We focus them on violent crime, cocaine, methamphetamine, and heroin dealing, serious economic crime, and public corruption. And what I learned in your case was it makes no sense to focus any of our resources on medical marijuana. Medical marijuana is really an issue outside the law enforcement ambit at this point. It's largely a zoning and a land use issue. Mm-hmm. We're going to focus on other things. Now, what I learned from your case and from talking to others is there's a lot of people, good, sincere people, who believe that marijuana has a very legitimate medical purpose and that it makes a difference in their lives. I've learned that from a lot of folks.
Great. Thank you for that. Honestly, I appreciate that. Now, in regards to your business card, I noticed that it says tough fare and on your side on there. Now, in regards to if you do become Attorney General of Colorado,
the bumper sticker says that too. It's on the
does
website.
It?
It's on the website too. Yeah.
Well, in regards to that statement,
yeah,
and
sure.
and potentially becoming the future Attorney General of Colorado, how would you apply those words to cannabis, to medical cannabis?
Well, first of all, we picked that slogan because I think it really distinguishes me from the incumbent, who is not on the side of ordinary Coloradans, not on the side of working people. He's on the side of payday lenders and big business, almost any chance he gets. But also on the issue of medical marijuana, he's not on the side of patients, is my view. And he's neither tough nor fair. I mean, any law enforcement lawyer, attorney general, district attorney, has to know how to balance being tough, cracking down on things, but also not overusing the power of the government. I think in hindsight, it's fair to say that although I learned a lot from it, and there's a lot of good that came from it, that taking your case to trial was tough but not fair, and was not an appropriate use of resources. The incumbent isn't particularly good at learning and adapting to realities. He has not been at all open to the reality of dispensaries, which I've always felt dispensaries were legal under Amendment 20, and now they're endorsed essentially under the medical marijuana scheme, medical marijuana center scheme endorsed by House Bill 1284. John Suthers continually wants to turn the clock back on marijuana issues to the law enforcement environment of, say, the mid-70s. So I would say I will be on your side because I'll be on the side of the law and on the side of the Constitution. John Suthers will not be.
Okay, great. As Attorney General of Colorado, you would be in a strong position to create a positive dialogue with the federal government in regards to protecting medical patients who use cannabis from federal prosecution provided by the state protections of Amendment 20. Would you utilize the 10th Amendment on the constitutional level, which is states' rights protection? Would you be able to use that to protect patients in Colorado based on Amendment 20?
You know, I honestly, I'm not a big, I won't say I'm not a fan of the 10th Amendment. The 10th Amendment is part of the Constitution. It is there, and obviously we need to utilize it. My view of 10th Amendment jurisprudence is that there's not much there that would be of help to us on our trying to deal with medical marijuana in the states. You know, we have the case from 2006 in which the U.S. Supreme Court upheld on interstate commerce grounds the ability for the federal government to prosecute state medical marijuana issues in California. But I would certainly look at it. I mean, what I'll tell you is I give it a hard look. It's going to be a difficult legal issue. If there's a 10th Amendment argument that is credible and not laughable, like I think John Suthers' 10th Amendment argument on healthcare is laughable, then I would certainly pursue it. But I think more importantly, what I will bring to the Attorney General's office is a willingness to dialogue with the federal government, to set up good relations, to set up a task force, to help them understand how we're handling medical marijuana in Colorado, and how, as I mentioned before, it's all about priorities. And the federal government has a lot of resources that can help us keep the community safe here. Spending those resources on medical marijuana is a complete waste of time. In the Barkowitz case, shows that more than any other. That's an outrageous injustice that Mr. Barkowitz is undergoing. If I was Attorney General, I would do everything I could to dissuade the federal government from pursuing that.
That was my follow-up question, actually.
Yeah,
it was about Chris Barkowitz.
It's a very, very sad situation. I can't even understand quite what's happening, other than perhaps some people in the U.S. Attorney's Office want to play out the Barkowitz case to see how the case law develops, so they kind of know what they're dealing with. But
so similar to my case.
Yeah, similar to your case, although I don't know that they're learning as quickly as I learned on your case.
Yeah, I actually have been sitting in on a lot of the hearings, and I've heard some pretty outrageous statements from the prosecutor.
What I can tell you is that Mr. Barkowitz has an excellent lawyer, one of the best criminal defense lawyers in the state, and so I'm sure that everything will be done to protect his rights. But the real injustice there doesn't have a whole lot to do with legal rights or anything else. It has to do with prosecutorial discretion, where what needs to happen is the U.S. Attorney needs to say, this is disproportionate, it's a waste of time, we got other stuff to focus on, either resolve it at a very low level or dismiss the case. That's what should happen.
Would you be in a position to have that dialogue with the Attorney General?
Absolutely. Absolutely.